Good morning, ma'am. Are you Alacia Mouton?
Yes, ma'am.
And Ms. Mouton, in cause number 25 DCCR 0907, before we go forward, I'm going to take judicial notice of the court's file. It looks like there was an evaluation done by Dr. Capon last year with regard to competency, and that we received that report back in October, and Ms. Mouton was found competent to stand trial. Is there...
Did this in January 20th.
The competency report's from October.
You found her competent January 20th. That's on my file for sausages.
Okay. Maybe we didn't get her back. I don't know why.
She did a lot of things.
Hold on.
I don't think she was ever taken anywhere.
No. So I don't know why. Anyway. Found competent based on that report. There hasn't been any other reports that I know other than the Dr. Capon report from back in October. And so any other issues at this point with regard to competency? All right, so in cause number 25, DCCR 0907, Ms. Mouton, you're charged with a second-degree felony offense of assault on a peace officer. And what that means is that if you go to trial and you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand? I need you to answer out loud for the record. Thank you. And then in cause number 25, DCCR 1466, you're also charged with assault on a peace officer. This one is from August 17th of 2024. The first one that I read out was actually from May 5th of 2025. So this second one, same thing, is a second-degree felony. If you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1467, you're charged with the state jail felony offense of possession of a controlled substance from August 17th of 2024. And in that case, that means that if you went to trial and you were found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand that?
Yes, ma'am.
And then in cause number 25 DCCR 1468, you're charged with assault on a peace officer, and this is from that same date of August 17th of 2024. Again, if you're found guilty by a jury, the same punishment range applies, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then the last case is 26 DCCR 0120. You're charged with possession of a controlled substance, a state jail felony, from August 8th of 2024. And in that case, if you were found guilty, the range of punishments between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
I have here on the tablet plea bargain rejections that you've signed with Mr. Rojas. It shows that the district attorney's office has made offers in your case if you wanted to enter pleas of guilty for 8-year term in prison and on all of those assault on a peace officer cases that would run at the same time concurrently, and then a 2-year sentence in the state jail prison on those two.
The offer was actually we would dismiss the state jails, Judge.
Okay, so there would be a dismissal in the 2 state jails with, I'm going to make that notation.
So I just signed everybody's refusal 2 years of both of those.
You did, so obviously the bigger cases are the 8-year terms. So what the offer is, and so that we're all on the same page, it would be 8 years TDC on the 3 assault on a peace officer cases with dismissals in the 2 state jail cases. Does that change your mind?
No, ma'am.
Okay, so you have every right to reject. Hang on. So you have every right to reject those offers. I just need to make sure that you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty, and you understand all of that.
Yes, ma'am.
And you want to reject those offers and have your cases set for trial.
Yes, ma'am.
All right, we'll get them set for trial. Ms. Mouton, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am. I thought you were trying to make me keep him.
Well, it wouldn't be the worst thinking of the best lawyers we have.
I understand.
So, Mr. Rojas, you're released, and Ms. Mouton will give you a new attorney. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Also, hold on, come back. Mr. Smith, do you anticipate there would be any reason for that offer to change?
Judge, I thought that was virgin or something.
So I do want to make sure you understand that just getting a new lawyer doesn't mean things are going to change. The offer is what it is, and so there's not going to be any change just because there's a new lawyer.
I've seen the tapes, and it's not enough on tapes to show that I deserve 8 years.
All right, but that'll be up to...
in 2 years.
That'll be up to a jury. That's what juries are for. And Mr. Parker, will your client move the formal reading of the indictment?
Hey, with the judge.
And we're just going in the possession case, is that correct?
That's correct, Judge, but on the, with the prior enhancement counts to make this a third degree, and just to be candid with the court, in 2019, he also received a 5-year sentence. This same 5-year offer was made based on the underlying facts of this offense. What he did was pour some PCP out on the floorboard carpet of the car, which made it difficult to measure the quantification.
Okay. All right, Mr. Calhoun, in cause number 25, DCCR 1266, you're charged with the state jail felony offense of possession of a controlled substance from April 14th of 2025. And how do you plead to that charge?
Yes.
And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Listen.
That indictment further alleges that you were previously convicted of unauthorized use of a motor vehicle, a third-degree felony, May 17th of 1993. After that was final, you were convicted of possession of a controlled substance, a third-degree felony, June 3rd of 2002. And then after that, you were convicted of unlawful possession of a firearm by felon, July 8th of 2019. And are all 3 of those prior convictions true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? He went over those with you? Do you fully understand those documents?
Some of them.
What do you not understand?
I gotta look at it to see it again, but most of them I do.
Well, let me go over a little bit more with you. Do you understand that if I follow the agreement that you made with the district attorney, that you'll be waiving, giving up any right to appeal? So if I follow this agreement, you can't change your mind later, right? And it looks like the agreement's for 5 years in prison with a dismissal in clause number 25, DCCR 1267, which is that tampering case.
Yes.
Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Calhoun is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
That time?
Yes.
No.
Just the time that we've had a hold on you here. So I don't know if you're serving time anywhere else or were anywhere else. Okay, so you'll get that credit. I'm going to hand you in just a minute a trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You're also going to be handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. You already know this because I know you have a history with a charge of this, but I'm required to read this to you. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And then I will sign a dismissal as soon as it comes through in clause number 25, DCCR 1267. Okay, all right. Here you go. You can go back with the vote. Good morning, sir. Are you Jermaine Duhan?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment? Mr. Duhan, in cause number 24, DCCR 2464, the state's elected to proceed on count 1 only. It alleges you committed the third-degree felony offense of obstruction or retaliation. And how do you charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tender 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Duhan is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right? Good luck to you, sir. You can go back with the bailiff.